Good afternoon, everybody. I hope this doesn't mean that you have a lot of obnoxious shareholders and owners living in your buildings. That would be terrible.
It's a very broad heading.
I'm Ken Jacobs. This is Dominic Tamaro, Emma Lupu. We're with the firm of Smith, Buss, and Jacobs. We represent about 350 co-op and condo associations in the New York metropolitan area. It's about 2/3 of them in the city, and then in some of the surrounding counties as well. We've been asked to talk about an ongoing issue. It doesn't matter whether you're a new co-op or a new condo or a condo that has been... What's this sound?
That's mood lighting.
Mood lighting.
Are they kidding? All right.
Somebody probably leaned on a switch.
That's objectionable.
Basically, everybody, we have all encountered the problem of controlling, channeling, dealing with the shareholder or unit owner who basically makes it difficult for the condo or co-op to operate, either by violating the rules or just basically by the facts of life and their character. So we know that everybody wants to deal with this peacefully and in an alternative dispute resolution. Sure, sorry. I don't think we're allowed to close the doors. Okay, I'm sorry. I stood up thinking you could hear. Okay. We realize everybody wants to do, at first we always want to deal peacefully. We want the co-op to operate harmoniously. The board members are volunteers, but sometimes that's just not possible. And we're going to be discussing today examples of how you deal with shareholders or unit owners where you have to go to the next step and actually seek to enforce your rules and regulations. Now, first thing I want to ask is, how many people here are affiliated with co-ops? Okay. Boy, how about condos? Okay, all right. So,
Raise your hand first.
I know. So all right. So we're going to try to deal with both of them. Anybody who was here this morning realized that the co-op, you have a corporation that owns the building. There's a proprietary lease. The co-op is the landlord. The tenant shareholder is the tenant, and the rules that govern the operations of the co-op flow very much from landlord-tenant law. But in a condo, it's not a landlord-tenant relationship. What the state does, what the courts do, is they treat the declaration and bylaws of the condominium as a contract among property owners, co-property owners. So in many, many ways, the rights and obligations of the unit owners and the condominium association flow from the contract, what's written down in the deck and the bylaws, and the rights and obligations of adjoining property owners, different from landlord-tenant. So when we talk about, so that leads to potentially different ways of dealing with objectionable tenancies and objectionable conduct. There are certain remedies that are available to co-ops that aren't available to condos, and potentially vice versa. Now, as I said, there are two types of objectionable conduct situations. One of them is the one that violates the rules, where you have a clear violation of the rules and regulations of the building, and then you have remedies that are set forth in the declaration bylaws or the proprietary lease, and you exercise those remedies. And examples of those might be smoking in the common areas if the co-op has no smoking, and then the obvious ones, noise or violating the alteration agreement, things like that. And then you have the second type of objectionable conduct, which is the shareholder or the unit owner, or actually the shareholder, who makes it just very difficult for the building to operate. And that could be for a number of reasons, including compassionate ones. Somebody who's just getting older or suffers from ongoing dementia or can't take care of themselves in some way. Or you might have the bully or the chronic litigator, someone who makes it difficult for the building to operate, and you have to deal with them that way. We can't deal with every single example of objectionable conduct in 1 hour. What we're going to try to do is lay out principles that your boards can use in order to maximize your chances of controlling the behavior. So, let's just talk about then. Emma's going to talk about the generally the duties of the board in general. Now, one other thing, we have a little bit of a PowerPoint. I'm going to get up and press the PowerPoint. Not elegant, but it works. Okay,
So as a board, whether you're a condo or a co-op, you have a fiduciary duty to the entity that you serve, as well as to the individuals that are members of that entity. In a co-op, you have a fiduciary duty to enforce the terms of the proprietary lease for the benefit of all residents in the building. Very often, that leads the board into a very sticky situation where you have one or more residents complaining about a particular resident, and you're not sure who's telling the truth and who isn't. The board has a duty to investigate. The board has a duty to use whatever resources they have available to themselves in order to effectuate that investigation. You also have a duty to preserve the quiet enjoyment of those residents in the building. That's actually a section in everyone's proprietary lease, and if you're a pre-AG building and you have an occupancy agreement, that stands true as well. To some degree, that's also the case in condos. To a much more minimal degree, because your powers are much more limited in a condo as a board over your individual residents than it is in a co-op. In a co-op, you're a landlord. Your residents, while they may be shareholders, are also tenants, and they must abide by the terms of the proprietary lease. As a practical matter, the most difficult part of this is that you have to spend some money to do your investigation. Very often, it means turning it over to your management company, asking them to investigate the complaint, whether it's to inspect the unit, if it's a noise or an odor complaint. Those are very common these days. Noise and odors have always been prevalent, whether it's cooking odors, somebody just smells bad. Usually it's the neighbors that are complaining. Sometimes the neighbors don't want to be known as the complainers. They don't have much of a choice, because if the people don't cooperate, you don't have a case. So you leave it to your managing agent and, most importantly, your super, to go out and find out what's really going on. I can't tell you how many times I've had boards call me with an issue going on in a building, and I say, let me call you back, I need to speak to your super. Your super knows everything that's going on in your building. Whether they admit it or not, they know it all. So be good to your supers, because they can feed you every ounce of information there is to have. And your management company relies on your supers. They're there to supervise your staff, but they're reliant on your staff in getting the day-to-day information. So management can go out, they can do inspections, they can speak to neighboring residents, but your super's your key, because your super knows the residents. They know who's living in what apartment, who the subtenants are, who the illegal sleepovers are, who's hiding a dog or a cat under their bed, who's hoarding, that's a big one, who's smoking in their apartments. I had a very big smoking case in Suffolk County recently, and our super was key in helping establish our case and build our case. So your number one duty is to investigate and to get to the bottom of what's going on. And you have to draw on whatever resources are available to you in doing that. Sometimes that means spending money. And I can't tell you how many boards are very shy about spending money. But the truth is, if you don't investigate the matter properly, it'll cost you that much more in legal fees later on. Because it's much harder to build a case months down the line when you've gotten to your attorney's office than it is to make sure that you've detailed and kept a record of what's going on as it's happening.
condos are in slightly less advantageous position here, but in some ways, and in other ways they're in more advantageous position. Boards, because a co-op board is a landlord, there is a huge body of landlord-tenant law that says that the landlord has an affirmative duty to investigate and to resolve the problem to the best of its ability, or it's potentially liable to the tenant. You have some principles called breach of warranty of habitability and some other tenant-oriented principles. But condos, there is no breach of warranty of habitability in the condo. If there's a leak into your apartment, you can't withhold common charges because, like you can in a co-op, because your warranty of habitability is being breached. But as remember I said that you're dealing with these like adjoining property owners. The condo board has a duty to investigate, but it does not necessarily it is not charged with the responsibility for solving the problem necessarily. If there's a problem between two unit owners and one unit owner is complaining about noise from another unit owner, the condo board does have the option of saying to a unit owner, we've investigated, we've done what we could, and if you want to do anything more, you have to do it on your own. You have to go to start the lawsuit against your adjoining property owner, and you have to deal with the problem. A co-op board doesn't necessarily have that luxury of doing that.
I just want to add one thing to that, and that is a lot of board members, in my experience, and even property managers to some degree, feel as though it's for the shareholders to deal with each other. I hear it all the time. You're an owner. You have to deal with the guy upstairs. The leaks are constantly coming in. You have to deal with him. The noise is happening. You have to deal with him. I can't possibly say it enough to my boards. That's just not the case. The board is on the hook. The board is on the hook. The board is on the hook. You have an absolute responsibility to resolve the problem for the individual who's feeling the brunt of it. And yes, that's going to involve spending money, but that's the cost of doing business. And you have no choice but to address it. And if you address it properly, perhaps you can recuperate some of that money further on down the line. We just received a judgment for close to $60,000 in legal fees against a shareholder in a co-op that was smoking in his apartment after a protracted investigation and trial process. And the board was very happy, but it took a long time to get there. And a lot of money invested without a promise to a return, but they had no choice. And the most important thing that I want every board member to walk out of this room with is the understanding that you can't pass the buck onto the offending shareholder in a co-op. It is your responsibility to deal with as a board.
Yeah, I'll let you comment.
Can I just-
Sure, absolutely.
Okay, yeah, I just wanted to add one point.
Dominic, you're not supposed to talk until later in the
The distinction between a co-op and condo and the remedies they have to deal with these issues. In a co-op, if you're correct, ultimately you can terminate a lease and evict someone from the property, which is very severe, okay? It's a very powerful tool. In a condo, it's not the case. They're an individual unit owner, okay? You can get injunctive relief from the court, which is basically an order saying you're not supposed to do this anymore. Stop this objectionable conduct or breaking of the rules. Now, sometimes you can fine them, which most co-ops don't, and you can hit them in the wallet, so to speak, and that would make the person stop such behavior. But there's certain objectionable conducts in condo where finding them is not going to solve the problem. Getting an injunctive relief with a court order saying stop this action, they may not. And then you're forced to go back to court, more or less saying they're in violation of the order. And does the judge step up and hold them in contempt of court? It depends. It's very fact specific. I mean, ultimately, you can sue them along with your injunctive relief and get a judgment for your legal fees, but it doesn't necessarily solve the problem. So your hands are a little more tied in a condo as opposed to a co-op.
Yeah. So, sorry, so we're going to apply this to some specific issues here, okay? And the general principles we want people to follow. How do you maximize your ability to prove your case if you have to? How do you maximize your ability to exert leverage over the offending owner or shareholder, okay? Number one, you get a complaint, okay? Get independent verification. What that means is building staff, can they verify it? If somebody, I'm going to apply this to a smoking as an example, okay? If somebody says, I smell smoke in the hallway, all right? See if you can get somebody up there and say, do they smell it as well? It's a key issue. Is this a valid complaint? Second, keep a log, and that applies smoking and noise, for example. You get a complaint from an adjoining apartment owner saying, I smell smoke in my apartment because the guy next door is smoking. He or she should write down next to him that smelled smoke 9:30 p.m. He should complain to the doorman or the super, somebody on the building staff who would write down in his log, received complaint from Unit 4B, 9:30 p.m., smoking, all right? You build up this record, and it actually can be used in court under certain circumstances, and we'll get to that later on. All right, the third thing is identify potential witnesses. What I mean by that is not just verifying by a log or having building staff record your complaint, but if you can show, if more than one person is generating the same complaint. That will improve your chances. It enhances your credibility. Instead of being the crazy neighbor who says, this guy is making noise, you have 3 neighbors complaining this guy is making noise. So these are our principles that we apply. Let's apply this to smoking as an example, okay? So you get the complaint. The first thing you do, you notify the shareholder or the unit owner. Smoking is a nuisance as a matter of law in New York City. And so if you can prove somebody is smoking, that it is potentially bothering you, then a court is likely to rule that person can't smoke, or and the co-op has a duty to mitigate the problem. The condo has a duty to investigate the problem, but we'll get to them. It does not necessarily have to make sure the problem goes away unless the problem affects the common elements. I'll get to that. Yeah.
Is this in a no-smoking building or?
Both. Both.
There's a general provision in most co-op proprietary leases that prevent the emanating of smoke from someone's
Odors.
unit.
Odors, yeah.
Odor.
Yep.
Right.
18B of most proprietary leases.
Right. So, yes, somebody's going to say, well, I have a right to smoke in my apartment. Well, if it exfiltrates into the hallway or it exfiltrates into somebody else's apartment, then he or she loses that right. But there are some caveats here, okay? First thing the co-op or condo should do is look at options to fix the problem. Maybe there's a way of keeping the smoke from exfiltrating. The traditional ways, the tries are you put the weather stripping on the bottom of the doors, and
Cover the back of the outlets.
yeah, you
Caulk.
caulk the vent, you caulk the outlets, you look for cracks in the floors, and you try to keep it from going into the other units, and that's terrific. Except there are problems with it, especially in modern buildings. Okay, the weather stripping. Well, every time you open the door, the smoke still comes out into the hallway, and so it doesn't necessarily solve the problem. Some people try to say, well, open the window. Windows actually create negative pressure. And again, it pushes the smoke into the hallway. It exacerbates the problem. Maybe a smoke eater fan might deal with this. The board, you can try these. You can try to solve these problems. However, this may work against the board, okay? Because sometimes in modern buildings, interconnected ventilation systems, all right, it means the smoke goes up into the ventilation system. You can't even tell what apartment it's coming from. And you can't solve the problem by caulking outlets because it just goes up into the ventilation system. Modern ventilation systems are susceptible to this. Or older buildings particularly, between the walls, there are voids. The insulation has fallen away, let's say, or just wasn't properly built. And so the problem is the smoke gets in between the walls. Well, that's not the duty of the shareholder or the unit owner to fix. That ends up being the duty of the co-op corporation or the condo association, to go into the common elements between the walls and seal them up. And that can cost tens of thousands of dollars. So to avoid that problem, some co-ops and condos, many of them actually, have amended their proprietary leases and bylaws to prohibit smoking within units. There's a, yes, oh, excuse me, yes, all right. There you go, okay. That will take a vote of the shareholders, but we found it surprisingly popular among buildings, because, especially a lot of the condos, because it's a way of avoiding this whack-a-mole problem of figuring out who's smoking in what unit, and you stop it this time, and they don't stop it the next time. And condos don't have as many tools to control the owners as co-ops do. We have litigated and enforced these amendments, and I'm going to turn this over to Emma again. Don't worry, Don will talk. To talk to, we actually litigated and just got a case, the first known case actually in New York State, where a no smoking amendment was enforced in a co-op. Previously, we had gotten, I see my partner Jack Malley is there, succeeded in litigating a condo amendment to enforce a no smoking amendment in a condominium. So, Emma, why don't you talk a little about your case?
So our case started as a very typical example, like Ken just went through. There was someone smoking, and it wasn't a high-rise building with hallways where you can literally walk into the hallway and just sniff like a dog and try to figure out which door it's coming from. Sounds funny, but most odor cases, whether it's smoking or any other kind of odors, that's what I tell my boards to do. I send the supers upstairs. I have all of the neighbors walk in the hallways and do the sniff test. Tell me where it's coming from. Because when I put you on the stand to testify, I want you to tell me. I walked in the hallway, I sniffed, it was strongest next to this door. It's actually a good way of proving where it's coming from. But in this building, we had the ventilation issue. And that is, there was a common ventilation shaft. And what we think was happening, because we're never really going to know, because nobody ever actually got into the apartment to see anyone smoking or smell smoke, because access was an issue. You had to give notice. When we went without notice, they wouldn't let us in. So what was happening was, it was coming, they would smoke in the bathroom and turn on their fan. How many people know people who smoke on their bathrooms and turn on their fan? That has to be the most common. Nobody. So they turn on their fan, and what would happen is the smoke would get pulled into the building exhaust and go into this shaft well that opened up into everybody else's apartments. And if they didn't have their fans on to push the air out, it would come in. And the problem was horrific, and it was horrific for the neighbor downstairs. The neighbor next door moved and sold their apartment. The neighbor on the other side couldn't breathe, filed a HUD complaint against the building, claiming that we were discriminating against her, and we had to defend that. It was a nightmare. What did we do? We started with a log. Ken alluded to a log. A log is nothing but a piece of paper sitting next to your bed or on your nightstand or on your coffee table or wherever it's most accessible. 3 columns, date, time, description. I ask every single person who even gave me one smoke complaint, I need you to please maintain a log. By hand. I don't want you to type it in your computer. I want you to keep it by hand. And every time you smell smoke, you just walk over and you write down the date and the time and give me a quick description. It's cigarette smoke lasted 20 minutes. Something very vague. Now, this doesn't only work for smoke. It works for noise. It works for any other type of default that needs to be proven through testimony. What's the benefit of the log? I had people who came into court with 17 pages of notes. Yes, that had spanned over months and months and months. Even while the case was going, I was having them maintain their log. It lends a level of credibility to the witnesses. When you get up in front of a judge, it's a conspiracy. They all hate me. They want to get rid of me. I used to be on the board. They didn't like what I did, so now they concocted this big story. Really? Who's going to sit there for 4 months and write dates and times down if they're conspiring? In addition to that, it's the recollection issue. A log is actually admissible as evidence. Ordinarily, the only evidence you can give at trial is testimony of what you yourself saw. You yourself are not going to remember 89 different occurrences of smoking. And if you have to sit there and pull every email that you sent to management about it, it becomes very difficult testimony and it loses some credibility along the way. The log is actually admissible for the facts that it contains. So it's as if you were testifying to 89 different incidents.
Contemporaneous recollection.
It's a contemporaneously recorded recollection. There's an exception to the hearsay rule, which allows you to admit the actual document as evidence. We went out, we sent the super first to investigate. The super says, I have a poor sense of smell. AKA, I don't want to get involved. So, that's really what it is. So we said, okay, fine, you have a poor sense of smell. We decided to do dust swipe tests to try to figure out who was smoking on that side of the building. So we hired a company that came out with little alcohol swabs. They look like wipes. And they took swipes in 2 different areas in every single apartment in that building. Comes at a big cost. It cost almost $11,000 to do. Yeah, it's not cheap. It was, I think, $250 a swipe plus the visit. It adds up. Like I said, you have to spend money. You don't really have a choice. And this building didn't have a choice because they were getting complaints left and right. One person had filed a HUD litigation against the building. The other one was ready to start withholding maintenance. It was a problem. And they had a lot more to lose on the other end if they didn't pursue it. So we got the dust swipes. The dust swipe test results come back. Of course, everybody comes out a little bit positive because the nicotine travels. And one person, actually 2 people, were overwhelmingly positive. And it was the person who we thought it was. and one other, which was a surprise. So we waited, and we asked every single person on that side of the building, please keep your logs. Everybody did, because they couldn't live with it anymore. When it got that bad, they just couldn't live with it anymore. They maintained their logs, and we waited. And we waited until the one that we thought wasn't smoking was away on vacation. And lo and behold, she was away for 2 weeks in Florida, and still the smoke complaints came. So now we knew for sure where it was coming from. We served a notice of default. The notice of default is every proprietary lease requires that you serve it. And it says to the shareholder, you're in default of the lease. In this particular situation, the shareholders had gotten together and passed an amendment prohibiting smoking. Because of the problem that Ken identified earlier, and that was having to prove where it's coming from would require colored smoke going up through the exhaust system, trying to follow it. It was too complicated to do and too expensive, and it was easier to just pass a no smoking amendment. And the shareholders got together, they passed the amendment. We were able to serve a default notice, notifying the shareholder they were in default. They didn't cure, the smoke continued. They insisted they weren't smoking. Now, they weren't saying it's coming from somewhere else. We just don't smoke in our apartment. That was the story that we got.
You have witness.
They had witnesses, ultimately, friends, who visited their apartments who swore up and down they'd never seen them smoking, as opposed to the 11 witnesses that we put on the stands. We had the 2 living below, the 2 that used to live next door, the 2 living on the other side, another one that was further on down. We had the super. We had a lot of witnesses. The trial went on for close to 5 days. In Suffolk County, this trial happened, and in Suffolk County District Court, I'm not sure when was the last time they saw a 5-day trial, but it was very prolonged and a lot of witnesses and a lot of testimony, and it took us almost a year to prepare the case. We weren't going to go in and lose. You never want to start a case thinking you even might lose. So it's about gathering your testimony, and I always say we won the case and you win every case before you bring it. It's all about your preparation and how you prepare yourselves and your testimony going in, and your witnesses.
Yeah, so investigate, the principles, investigate, keep a log, okay, and if you need to use expert witnesses, whether they're medical witnesses or engineering or consultant, environmental, and then have support witnesses going into court, these principles, yeah.
Why could that case not be pursued as an increased risk of fire hazard? You had an open flame. They could have gone anywhere in the apartment.
Because I didn't have one person who could testify that they saw them smoking in their apartment.
They wouldn't allow access, and that's actually a very typical problem.
So the idea was you had a no smoking amendment. Smoking was prohibited. Every single person came in and testified that they smelled smoke in their apartments. They all said it came strongest from the part that they maintained a common wall with this individual. One person said that he had walked past the front door one day and smelled smoke. There was lots of little pieces of evidence that all gathered together made the case.
And plus, what you said, the open flame would have to violate some law or statute, which I'm not necessarily sure it does. It violated the no smoking in the building, and that ultimately was the basis for the action. But someone having a lit cigarette in their apartment may necessarily not violate a law.
It doesn't.
Yeah.
What did they amend?
They're proprietary lease.
You amended the proprietary lease, or in the condo, you would amend the bylaws. Okay, so look, that's an example of how we applied these principles in a court case, all right, with a violation, and we enforced that. But there are other examples of objectionable conduct which are not nearly as clear-cut. They're not necessarily violations. They are they trigger another section of the proprietary lease, which we call the objectionable conduct section, and that has different ramifications. And I'm going to change I promise I'll change the picture, and Dom McNamara is going to discuss the objectionable conduct clauses in the lease. And
Okay, just to be clear, these provisions are not contained in the bylaws for condominiums,
Yeah,
so you don't have
condos
these
don't have
rights.
this option.
Okay, you don't have this option, but they're just about in every proprietary lease I've ever seen. And they basically give either the board or the shareholders the ability to conduct a vote at a meeting to terminate someone's proprietary lease based on objectionable conduct. And there's actually two different, routes. One would be someone violating the rules, whether the proprietary lease or the house rules, repeatedly after notice. That would be objectionable conduct. The second would be, it's the version of, just give me a second, I'm just gonna look at the language, loose or immoral character or criminal behavior, okay, depending. You have to look at each provision because it's specific in nature, and it's very important if you're going to exercise the remedy under the provision to follow it, because ultimately it will affect your ability in court to terminate the person. The courts have held that either the board or the shareholders' right to make this decision is protected by something called the business judgment rule, meaning the courts, when you go to evict someone, will not look at the reasonableness of the decision. They just want to make sure you follow the procedure correctly and that the decision was made in good faith, that they had the ability to exercise that right, meaning there's a provision in the bylaws, and it was for the benefit of the cooperative. And if you meet all those criteria, you can enforce it. An example of immoral, loose character, recently in one of our buildings, a new shareholder moved in 2 or 3 days later, or maybe simultaneously, someone moved in with them that was a level 3 sex offender, which is the worst type of designation. And it has a type of designation where they have the high propensity of committing the similar crimes in the future. So now the board had a couple duties. One, it had a duty to put everyone on notice of this potential hazard. It's no different than a broken lock on a gate in the backyard or some other things that might be a hazard to the shareholders. The second, they said, what can we do? My initial concern was, well, geez, people are, their right to have a roommate is protected under New York State law, but because of this provision that we're looking at here, they had the ability to basically put them on notice that this is a violation of your lease. If they do not vacate the apartment, and in this case, the board was going to call a special meeting for the purpose of conducting a hearing to decide whether or not to terminate the lease.
In other words, it was a violation of the lease because it was a person of loose or
Correct.
immoral character. The board decided that. It wasn't, you didn't have to send it's not something that's curable.
It's not curable. There's no, if you don't do this in 10 days, we're going to terminate. There wasn't. It was more or less we became aware of it. We gave them an opportunity, a short period of time to get out.
Yeah, we had a building, see, a resident of the building actually is here now, a Peeping Tom. All right, same thing. We found out he was arrested. The board immediately, we sent a notice of objectionable conduct and our intention to terminate the lease, and we reached an agreement where he wouldn't come back to the building. But we didn't have to go through, if you repeat the behavior, then the board's going to terminate. Imagine if you had to do that. Oh, there's a murderer. Well, if he does it twice, it doesn't work that way. Okay.
Well, that goes beyond just your loose and immoral character individuals. We have one going right now that we're actually having a meeting on just next week to decide whether or not their lease should be terminated, where the guy is just an alcoholic bully. He gets drunk, he starts banging on people's doors. He got served with a notice. He knew who complained about him. He started banging on their doors. He calls people rotten names in the hallways. He corners them, and he doesn't actually physically hurt anyone, but he's a big guy and very threatening, and he's cursing at people. He filed baseless lawsuits against individual board members after he was put on notice. So the board's is put them on notice that his conduct needs to stop, and if it doesn't, they're going to hold a hearing to determine if it's objectionable and whether or not they want to terminate him. And we have a hearing coming up next week, and the hearing's before the board. The board is the judge and the jury, and I will present the evidence of what he has done and what he continues to do, and the board will take a vote. And if the board feels that it is not in the best interest of the co-op to continue to allow this person to reside there, then they're going to move to terminate their lease. And it's a drastic, drastic step, because what are you saying to someone who owns shares? You're terminated, and then you're going to evict them. And they get evicted, and then their shares get sold at auction. So not only are they losing their apartment, but potentially the value of the asset. That doesn't mean that you can't give them a chance to sell later on down the line, but oftentimes by the time the board is done with an eviction proceeding, they're so fed up with the person, they're not giving them any chances at that point.
Yeah. Now, they're just important to follow due process on this, by the way. It is an extreme remedy. You must give the person whom you're going to terminate a chance for a hearing in front of if the board is the entity that makes the decision, in front of the board, if the shareholders are the people who are making the decision, and you'll see there's two different clauses. Proprietary leases have two different clauses, one saying the board makes the decision, one says the shareholders make the decision. But either way, you have to provide a hearing. He has the right to come in and present his own testimony, and then the board makes a decision. But once the board makes the decision, the court will not review that decision. In other words, the shareholder can't go into the court and say the board was unreasonable and that you wouldn't have done this, would you?
Or I've stopped.
But they
Yeah.
could attack their business judgment.
That's correct.
That's all, yeah,
Yes.
which is difficult. Okay, yeah.
Yeah, if the shareholder has a mortgage and the bank holds a pledge of the shares, does the bank have any say, or you can sell it?
You have to put them on notice. All the notices that you serve on the shareholder, regardless of what the default is, whether it's monetary, non-monetary, objectionable conduct, doesn't matter. The bank has to be put on notice. Under the recognition agreement, you have to give them 10 days notice, 15 days, excuse me.
A non-payment, they can have the right to cure.
Correct.
Right. I don't know how you
Non-monetary
cure a-
defaults,
They
they're
can't
just along
cure.
for the ride.
Right.
In my co-op, our management, for the popular word beds, people coming in to apply for apartments, does background checks, but only domestic ones. If we were to find out that someone we allowed to buy an apartment has a criminal record overseas, is that considered in this area that we can evict them for that? Or must they have done some illegal act since they got into the co-op?
It depends on the act. I mean, is it tax evasion? Is it something,
Something with business or taxes, something on that line.
I have never seen, and I haven't read either, of a co-op that has acted on the basis of some civil crime, something where there's no conduct issue, except in the extreme cases of a level 3 sex offender, where a co-op has done that. It is a drastic remedy, and you need to take it seriously.
Well, there's someone just has a hand right there. Yes.
What if it is a board member who?
Well, then they're perfect.
A board member whose shareholders deem objectionable? Well, on a different level, not on topic, but I can give you a quick, So, the shareholders have the power to demand, to sign a petition demanding a special meeting of the shareholders to remove any particular member from the board. You'd have to have a certain percentage of shareholders depending on what your particular bylaws, this is a bylaw issue, not a proprietary lease issue. You demand the calling of a shareholder meeting for the purpose of removing this particular board member and electing a new one. And you'd serve that petition onto the board, and then the board would have a duty to call the meeting. If they don't call the meeting, you can go into court and have a judge order that the meeting be held. At that meeting, you'd have to get quorum, and you'd have to have a sufficient amount of people voting to remove the board member. Now you come up against your typical problem, right? Everyone's afraid of them, so they don't want to vote them off. And what I can tell you in that scenario is move. Because if you can't get people to stick up for themselves, it's not a battle that you can win. And, it might take some lobbying, it might take some door-to-door knocking and getting the famous proxies and getting it done. I mean, we've represented many, many shareholder groups over the years in buildings where they needed to oust the board for one reason or another. Whether it's one particular individual or a group, it didn't matter. But there's a process for that.
I don't want the condos to feel left out.
No.
I wanted to add a point
That
about
goes in condos,
very
yeah.
similar to the example Emma was giving about her most recent case with objectionable conduct. We have one recently. I actually worked on it with my partner, Jack. Unit owner. He's a steroid user, alcoholic, and has mental issues, okay? And he became very abusive, not physically, but where he would just scream the craziest things at people that walked by off his balcony. He would slam his door repeatedly 20, 30, 50 times just about every night as soon as he started to drink. He threatened to cut people. Things in today's society just are unacceptable. So, the board had two choices. They could fine him, okay, which wasn't going to work. And plus, you have to have a hearing under their bylaws before you can fine the person, and none of the board members on a volunteer board wanted to face this guy at such a hearing. So we took a legal action. We sought a temporary restraining order for this behavior and a preliminary injunction, and via summons complaint, we sued him for a violation of the different rules. It worked out from a practical stance. We understood that he bought the apartment with his mother, and sometimes what I see in these situations, the family member kind of parks the problem. They get it out of their house, they put it in your building, and it's your problem. You know, it happens all the time. But since she was a co-owner, her equity was going to be impacted by, you know, we would have obtained a judgment for our legal fees, and it would have been on her unit as a lien. So she stepped up, removed her son, who was an adult, okay, sent him to some sort of out-of-state clinic, and basically the allegations in the complaint were so strong, she put the unit on the market and is in the process of selling it now. But, you know, we lucked out with the non-legal part of the, you know, because there was equity in the unit and there was a family member that was a co-owner. But if not, the person could have came back. As long as they didn't partake in it, they could stay there. You can't remove them.
And that's one of the issues with condo representation. The bylaws are very crude. They're very crude tools. And some condos are considering, I'm reviewing condo bylaws now, and they're considering whether to try to create some more flexibility to allow more tools to deal with the objectionable unit owner, because condo issues are very much governance issues right now. But it's a difficult issue. Yeah. Yeah.
You said the right to terminate someone's lease requires a vote, right?
Yes.
Of the board?
It
Depends on the provision.
And where does the provision have to be, in the lease or the?
It's going to be the proprietary lease.
In a co-op, it's in the proprietary lease. It's in paragraph 31 usually.
If it's not in the lease, then what?
Well, then you don't have
Then
it.
you don't have it.
Then who doesn't have it?
Well, in order to, okay, the rights and obligations of both the cooperative as the landlord and the shareholder as the tenant are contained in the proprietary lease. So if that remedy is not there, then you don't have that right.
Is that provision of voting I'm talking about?
Right.
Correct.
In the proprietary lease, the clause that's up there, as a matter of fact, is a typical clause in the lease, which says the board either the board or the shareholders, depending on your lease, can vote to terminate somebody's proprietary lease because of objectionable conduct. And that vote is not reviewable, but they have to offer a hearing and an opportunity to
It just says objectionable conduct, and I have like a couple of sentences. It doesn't say who has the right to terminate it.
well, that's,
We'd have to look
Do you
at
have
that.
a proprietary lease or an occupancy agreement?
You know, proprietary.
That's rare.
okay, it's HFC, so it would be, yeah, but they
No, it says
frequently
it
have.
in HDSCs.
Yeah, I know that, but it would frequently have an occupancy agreement to it. It would say it in either one, but, okay, we can, okay. Well, I know you spoke to me about that, and if you have it with you, we can look at it afterwards. Do you have that?
I'm confident to tell you it's not in there.
Okay.
Well, then you wouldn't have the right.
I'm surprised, because most proprietary leases have it. And,
I would take the position that the board has the right. If it doesn't specifically say it, the board is the landlord, and the board would have to take that vote. What a court would say once you got to them, I can't answer for you, because every lease I've ever seen that contains the objectionable conduct language does say
I know,
by a
but
2/3 board vote or a 2/3 shareholder vote.
one thing they're gonna have to be concerned about scope of authority.
yeah.
You know, so we'd have to look at the lease. It might be incomplete. It might have been a typo, might have been copied over. There could be a number of reasons why it's not
They have
there.
an argument, yeah.
Yeah.
Okay,
Oh.
so let's apply this, sorry.
Getting back to the smoking, we're having a marijuana smoking problem. What was the person or persons you spoke about, what were they smoking?
Cigarettes.
Just regular cigarettes?
Yes.
Second question, are we gonna get to orders?
We'll get there.
Yep, we're going back to noise, all right, which is for some reason, people complain about it. That's one of our most common complaints, and I would guess it's probably here too. And it's also one of the most difficult, I'm sorry. Yeah,
Is this the case that you just documented? Isn't this also a situation where you would keep a log on this, or even install a camera to show that this guy isn't banging the door 50 times a night?
Yes.
absolutely.
Yes. Part of the investigative process, very often, I would suggest to boards that they install video cameras in that particular area. Keeping a log is just as effective. A video camera is great if you have the ability to do it. In my particular situation with the smoking case, it happened inside the apartment. Noise is, if it's happening in the apartment, it's very difficult to pick up. I've had people try to record it on their phones. I've had people try to videotape it. It's hard to hear on a recording device.
I could add one other thing in the example I just gave. a lot of the activity or conduct seemed like it was, the police should be involved. Because, it's, many times some say, this shareholder is doing this or doing that. And I was like, well, geez, that's a complaint for the police, not your managing agent, not your attorney. We're not there, And in this case, we were getting no cooperation. It wasn't in New York City, it was somewhere in Westchester, a particular town, and they just weren't cooperative. They were like, well, can't the building evict them? We were getting responses like that. So basically, it took 6 brave individuals to provide affidavits in order to bring the case forward. So
let's talk briefly about how we would apply these principles in a noise case. The general principles we talked about investigating and about keeping a log and about getting witnesses. And I'm going to ask, both Emma and Dom have war stories about this. If you could give a short synopsis, because people have been asking about the mental illness and hoarding issue, and that's the last thing on the
So
agenda.
I think with noise, the first thing you have to do is differentiate the acceptable apartment noise and apartment people versus actual unacceptable noise. And the clearest differentiating factor is always after midnight, after 11 o'clock at night, in the evening hours where the TV is blasted, the radio is blasted, they're running across their apartment. It tends to be very subjective. So where it's just the guy downstairs complaining about the guy upstairs, there's a lot of investigation that's necessary, and it makes it a lot more difficult to bring the case. If you can get the neighbors next door to corroborate noise, that helps. So it goes back to the same principles that we started with, and that is to get outside independent evidence and gather it and figure out if you have a case. At the end of the day, you typically address noise by checking parking, checking for carpets. All of your leases require carpeting. You may not enforce it, but the time to enforce it is when noise complaints come. Then you ask for subjective third-party evidence. When you hear the noise, call the super, have him come up to your apartment, let him confirm it. That's helpful. When it's happening in the middle of the night, it's better. But sometimes you have people who work at night, they're sleeping during the day, and any ounce of noise is bothersome to them. The answer to that is you need to be an apartment person. And, I always said there's apartment kids and there's non-apartment kids. Apartment kids who grew up in apartments know they can't run races through the house, they can't jump off the couch, they can't jump into the sunken living room or off the cabinets in the kitchen. My kids don't know that because they live in a house. But if they lived in an apartment, that's part of growing up and being respectful to your neighbors. So there's an element of trying to work it out before you go any further. Very often you can't, and...
Yeah, it's probably the hardest thing to get independent verification for, because I may hear the noise in my apartment, but the way the building's configured, you're not going to hear it to the right or left of me. And you just say, well, does anyone else hear it? And many times, there's no response. It doesn't mean it's not occurring. And also, anything after 12, obviously within reason. The people that have opposite hours might be making breakfast or having dinner, or, I can't tell you, they go to the bathroom 5 times a night and flush the toilet. Like, that's not, objectionable noise. Okay, that's living in an apartment. And some apartments are built more soundproof than others, and it's just the way it is. But it really goes to then, hey, you're complaining, you're the star witness. Start keeping a log, and we want it descriptive. Time, date, time, duration, type of noise, yelling, screaming, banging. They're throwing furniture around, all different things. More detail, the better it is. And then we start preparing a file, sending notices to the person. And many times when it's investigated, the property manager goes upstairs, they complain about the person below. They're hitting their ceiling with a broomstick, they're doing this, they're doing that, they're actually bothering me. Or we walk around on slippers and they're just, ultra sensitive. So it's one of the hardest things to prove, and it's very fact specific, and it takes time.
Which is why this independent verification and this contemporaneous records are we can't emphasize them more in a noise situation.
There's a question in the back.
Yes, if you enforce the carpet rules, you have to be equitable that, if apartment A has an issue with the carpet, then everybody must have carpets?
No.
Can you be selective?
Business judgment. The board can apply its business judgment as to whether or not it's the scope of enforcement of particular rules and regulations.
And look, the reality is that 99% of co-ops don't enforce their carpet rules until they get a noise complaint. So if you live upstairs from me and I don't have a problem with your walking, there's no reason why you need to have carpet. But if I have a problem with it, then you have to have the carpet.
Well, because the first thing we do, it's black and white. Either you have the proper percentage of floor covering or you don't. and basically depending on your house rules, the quality, the padding, or whatever it requires. So first step is property manager goes in, does an inspection, say you're in violation. So that does a couple things. One, it muffles some of the noise once it's installed, and number two, it makes you more aware that rules are being enforced.
Yes.
With independent verification, how about simply asking a neighbor who may have heard about your complaints down in the laundry room one day, volunteering to, next time that happens,
Absolutely.
knock on my door and I'll come in to hear.
Absolutely.
Be your witness.
It's great. As long as that neighbor, if it gets this far, is willing to say the same thing in court.
That's the key.
You know, that's, Emma had a drug dealer problem where everybody was afraid to go into court and testify against the drug dealer who they saw dealing drugs because they were afraid of him. Witnesses are important.
One more question.
What about noise complaints regarding the building systems, like pumps make noise, heat makes noise?
So the guy who lives on the lobby and happens to live next to the boiler room or upstairs from them. So that's a tough one. I mean, there's a reasonableness level. I think as a co-op board, I would think that the board would make some sort of an effort to minimize the level of the noise. But boilers make noise, and there's only so much you can minimize it. You can't turn off the boiler at night because the guy needs to sleep because everybody needs heat. So I think that the co-op board, like in the smoking situation, has a duty to investigate and see what it can do to ameliorate the problem. But that duty is going to stop at some point when you hit the reasonableness level.
I'm going to add something. That if this applies to both co-ops and condos, first of all, and second of all, there are statutory maximum noise regulations. In other words, in New York, you may not be able to have noise exceeding 45 decibels. So if that boiler exceeds 45 decibels, the condo or the co-op has got to comply. It's not a.
It's definitely more black and white.
It's more black and white.
What about anonymous complaints?
They're not very useful.
It's going to be anonymous action. I mean, they're not helpful. Like many people complain, we say, we put it in writing, and they don't want to. There's not much we can do.
You can investigate, but if you can't come up with independent verification of the complaint, so if you're making an anonymous noise complaint, good luck, nothing's going to happen. Because ultimately, there's an end game, right? And the end game is being able to bring legal action against the individual. Without witnesses, there is no legal action. And if you are not willing to testify to what you've heard, then you don't actually want it resolved. Because there's no magic button out there that's going to make it happen without the testimony of witnesses to prove it.
And your board members are volunteers, guys. All right? I always make a motion to triple the compensation of the board members every year at the annual meeting. All right? They're not your landlords.
But anonymous complaints, at best you could hope, if you complain enough to your property manager, he or she will send out a generic letter to that person saying, we received complaints about excessive noise coming from your apartment. Please be more courteous. It carries no weight. It does nothing to further an action if you have to take one.
There was a question in the back.
Well, I have two now. One, when you said something about 45 decibels,
Yes.
is that outside or inside?
Inside.
That's inside, but they start with a base of ambient noise. You're going to learn more than you wanted to. In other words, let's say if there's 2.5 decibels of ambient noise, it's not 45. Now it's 47.5. In other words, it has to be 45 decibels above ambient noise.
And now I forgot the second question.
That was my purpose.
The gentleman on the wall.
What if the management company refuses to send a letter that we have received complaints?
311.
Yeah.
311. So there are some very basic things that the multiple dwelling law provides that applies equally to co-ops as it does as well as rental buildings. And there are basic rules and regulations that the city of New York has with respect to habitability of apartments. So in certain circumstances, you can have HPD come out. It's not going to work for noise unless it's a boiler noise situation.
Right.
And I would guess that most of the time that's not a 45 decibel issue. It's usually a lot lower than that. That doesn't mean that it's still, it might be legal, it may not be reasonable.
Right.
So I think there are elements below legal that cross reasonable. If you're talking about noise, 311 is not going to help you. But other issues that the management refuses to address and the co-op board refuses to address, 311 is your answer. The gentleman on the wall.
What about noise of the nails
the nails of a poodle or
The nails of a dog or a poodle?
Carpeting
Oh.
would stop that.
Yeah.
If there were carpeting in the apartment, then you wouldn't hear the nails of the dog on the floor. So the first thing your management company should be doing is enforcing the carpeting rule.
It's no different than someone walking around with their shoes on in the
Yeah,
apartment.
click lock. Wow, noise is a big one. Back?
How about a renter in a co-op building complaining about noise? from the
If a
shareholder?
renter complains about noise?
From a shareholder.
Well, your legal relationship is with the shareholder, the tenant
you-
shareholder,
yeah.
not the subtenant.
You'd have to complain to the shareholder, who would then have to complain to the co-op, and probably won't be allowed to sublet anymore. So, as a practical matter.
It's the person who was in the building when the building went co-op.
Oh, you're a sponsor tenant.
Stable.
So you'd have to complain to the sponsor, and then the sponsor would have to pursue management to have the matter addressed. You have the same rights a shareholder has.
Yeah, you're a tenant, yeah. I do, I would love to answer the questions, but I
We're
want to.
running low on time.
I know people have been asking about hoarding and mental illness, and it's the hardest thing. So if you don't mind, we'll stay. We'll be here afterwards, and we'll answer all your questions, promise. But I just.
I just wanted to say something in regards to 311. Telling the shareholders that they should call 311, I disagree, because those costs then go on to the shareholders, and
They
they
do.
have to take that on, even if it's something that they didn't do.
Unfortunately, what happens sometimes, and I've been consulted by a number of shareholders on this over the years, is you have the management company that passes the buck, or the board that doesn't want to deal with it. The board members that don't want to spend any money and say, you're an owner, you need to deal with your neighbor yourself. Yeah, it does pass the buck onto the shareholders, but at some point, the boards have to learn that they have responsibilities to their shareholders. And where when they're not living up to those responsibilities, 311 can be an answer.
What about for condos? Because I think 311
Doesn't work for
Yeah, is not as
It's
useful
not
for
effective for
condos. Yet
condos.
another issue.
But your face, because you have to pay for that violation.
What's your other option?
You would have to speak to your board and your management company, and you can send letters yourself.
That's
But
correct.
saying that you're gonna get a violation and that you have to pay for
Well,
it.
so the question that was posed was in a situation where you've done that, sent the letters, demanded the assistance from management and the board, and have been ignored. And believe it or not, that happens quite a bit, And
Saying your answer is to then pay a fine yourself.
no, you can hire a lawyer and sue the board, and that would be an option. But then the board has to hire a lawyer, and you're paying for a piece of that, just like you would be the fine. Correct. So it's
Unless
still
you're
the same
successful.
answer, unless you're successful.
And
Yeah.
then you would get
Then they
reimbursed.
paid your lawyer too, but you're really paying that portion of it too.
Look, yeah, New York's, the law regarding co-ops is basically oriented toward companies running businesses, so they make it more difficult for the shareholder to contest some issues.
The housing maintenance code law?
No, that would be, I'm really talking about, yes, when it comes to certain duties of landlords and tenants that would apply, but I'm really talking about, for example, suing a board and how difficult it is. It's just a very expensive and frustrating proposition because of the way New York law is oriented. Yeah, I would like to go to mental illness, not because we have answers, but because it's a difficult issue, and particularly in co-ops, we have very much an aging population. No co-ops are being converted, no co-ops are being built, so the population of co-ops is getting older and older, and we are encountering issues regarding dementia, hoarding, disruptive behavior in public spaces more and more often. And the question is, what do we do about this? Well, there's a balancing of interests here, all right? The co-op wants to first find somebody else who can help take care of this shareholder who is having the problem. So they may look for a family member, but they don't have a duty to find a family member. The co-op has a duty to protect its residents, and I say that with great regret and compassion. But if somebody is going around in their nightgown, screaming in the middle of the night, and it's happening again and again, the co-op has to protect the other shareholders. So the co-op can try to, and it's not necessarily something that is amenable to alternative dispute resolution. You can't have a mediation or a counseling session with someone who really isn't able to take care of himself. So you may need to actually consider legal action. And at that point, other things come into effect. So Emma, I mean, why don't you talk about
Sure.
what happens when you start the legal action and the role of APS here?
So very often you start legal action in these scenarios, not necessarily to get the person out of the apartment, but to get the problem resolved. And this hoarding stands on the same level as that does. Hoarding is a mental illness. It's been recognized by the courts as such. And there are innumerable cases out there on the issue of hoarding. Not always, it doesn't have to be garbage. It could be newspapers. It could be just a lot of stuff. I was in one apartment where there were literally roaches crawling up a wall, and the judge couldn't believe what she was hearing and went out and did an inspection herself of the apartment. So very often you commence those actions to stop the problem, not necessarily to evict the person, but to cure the conditions. One of the first things that happens when you get to court is you notify the court that you believe that there's a mental illness situation, and then they involve an agency called Adult Protective Services. And Adult Protective Services comes out and does an evaluation of the individual. And if they find that they're incapable of taking care of themselves, they will step in and they will ask that the court appoint a guardian ad litem for that individual in housing court. Sometimes it'll go a step further and they'll go into Supreme Court and ask for an Article 81 guardian to be appointed. That guardian would have power over both the financial and physical and well-being affairs over the individual.
Now, people have asked whether or not we should call APS first without even going to court, and that turns out to be less useful.
We've done it. It doesn't work.
Well, it's less useful because they have to cooperate with them.
Yeah.
And if the person they're lacking mental capacity, they don't think they have a problem, they don't take the bait. And many times when we go to court, they get served notices, they don't appear, it's on default. And so the court doesn't become initially aware of the issue until literally when you think you're at the end of the legal process, and then there's an opportunity to give notification, and it just brings you back to the beginning of the proceeding.
Even when you get to the eviction.
Correct.
stage.
When you're at eviction is where it comes up most of the times with APS. They investigate, it shuts down the whole proceeding.
If you have the marshal, who's actually going to conduct the eviction, if it's a senior citizen, will not do it until until there is appropriate notice, an additional notice.
Adult Protective Services.
We have been told we have to wrap this up. I'm sorry. We will be. Can we sit and answer questions after we wrap it up, or can we do it outside?
Okay, we'll be outside if anybody has any questions.
Yeah, okay. Oh, look. Bottom line is, please follow this is how you prepare yourself. It's going to save you money in the long run. Okay. Preparation is everything. Thank you very much, guys.